In prior videos, some people have left comments, and they often say things like, "My attorney did not do anything for me," or "I paid my attorney a lot of money and we got nowhere." I've heard I was able to get the results that I needed based on my own efforts and without the help of an attorney. I think that can be true in some circumstances. Of course, there are plenty of cases out there where I have been involved, where my involvement did make a significant positive impact on the outcome of a matter. So I do not doubt that there are some situations where people hire an attorney and the attorney is simply ineffective. Representing yourself in any court matter is always dangerous. You definitely want to make sure that you have picked a lawyer that you can trust. You want that lawyer to be competent for you, and you want that lawyer to care about your case. I firmly believe that anyone walking into a courtroom should have a lawyer with them. Hi everyone, in this video I'm going to talk about 5 tips for representing yourself in a family court case. My name is Kyle Kaufman. I'm a family law attorney at HKK Law Offices. You can find us at hkklawoffices.com. We love family law. It's all that we do, and we're happy to share some information with you in this video. I'm going to tell you some stories in this video. Before I do that, go ahead, subscribe to our channel. And if you like this video, let us know by hitting the like button. Now, when anyone comes to me and asks questions about representing themselves, I think of at least 5 things that are important. Now, for some of you, the suggestions that I will give in this video could be new, while others could be quite obvious. Either way, you will find something in this video that may help you in the representation of yourself, or even for the attorneys out there who are watching this, it may help you prepare for going up against a person without an attorney. Now, this video is not about ineffective lawyering, and perhaps that's a video for a different day. What I want to accomplish in this video is to help you with some basic guideposts to use if you're representing yourself. I will say that oftentimes the cases where a party does not have an attorney can actually end up being some of the most challenging cases that I have been involved with. And you might ask, how could that be? Well, the fact of the matter is that most attorneys are ethical, most attorneys do the right thing, and most attorneys move along the cases in a way that the issues become clear as you prepare for trial. We somewhat know the rules of the game, and the attorneys operate within the rules of the game. And part of family work and civil trials is to get clear on what the issues are, so everyone is on the same page. So there's been some sort of significant buildup in those cases that both the attorneys and the child's attorney, if there is a guardian ad litem, or the judge, now has some idea of what the general issues are. That does not mean that all the ins and outs of it have been resolved, but they have some general idea what the case is about and what they're going to hear in court. But when a party is self-represented, many times self-represented individuals really are not aware of the rules of the game and how to conduct cases. So they can be more combative, they can be difficult, they can withhold information. I often feel like as a lawyer I have to do a lot of extra work to prepare for all the random things that parties without attorneys do. And I think random is a good way to describe it. The rules of the game are just different, and we don't quite know what they are with an unrepresented person. I've seen pro se parties do all sorts of odd things that are in furtherance of their matter, that they think are good for their case, but may not be compliant with the law, they're not ethical, and sometimes even criminal. And I've seen plenty of pro se people make mistakes along the way. And the best way to describe it is that it's truly a wild card situation. And when I'm working with my clients, that can sometimes be frustrating for them, right? Because I promise them that I'll be prepared and overly prepared to anticipate all the zigs and zags that a pro se party may take in a case. I think it was Mike Tyson, the famous boxer, who said, "Everyone has a plan until they get punched in the face." Frankly, it feels that way when I'm up against a party in court when they don't have an attorney. They just operate differently. They march to the beat of their own drum. I may have prepared my case a certain way to create as much certainty as possible. I have to be ready for that punch in the face. And that's not literally, of course, but that's, somehow how it is. And I've heard other people describe it as the fog of war. You might prepare for a battle and you've got a great war chest, but once you actually get into it, things get quite hazy, things get difficult. Now, I don't know what that says about our legal profession, and that again could be a video for another day, but I will say that these pro se people sometimes can be very good in court, and attorneys, if you're watching this, you need to be prepared for that. Just because you have the title of attorney doesn't mean that you're the king of the castle or the decider or the person who gets to do whatever just because you're an attorney. I've seen plenty of people do quite well in court who are not represented. And, that's really the framework for these 5 tips that I'm about to give to you. So before I get into the framework, I do think it's important to state that I came out of law school, and I remember being challenged by people about legal questions and things that came up. And I often felt like, but didn't say, well, I'm the attorney. And you know what? Because I'm the attorney, I know more than you, and that's just the way it is, and it's going to be that way. And that was just really my natural defensive instincts, and other attorneys do that too. And we would think that way, and thankfully, I didn't say that out loud, I adjusted. But I've seen other attorneys think and act that way, and essentially act that they are higher and mightier than someone who is not trained in the law, that doesn't have the legal degree, that has not passed the bar. Now, some of you attorneys watching this would say, of course we know more, and that might be the case. But I'm convinced that somebody who focuses very well on their case, on their matter, who learns a lot, can become quite proficient and effective in court. As this is evolving, AI, ChatGPT, we're seeing that being commonly used in the legal world. All right, this is being used in law firms and by lawyers. It's being used by pro se people. The thing that you need to know about ChatGPT is that it's ChatGPT, it's AI, it's not the statutes, it's not a legal professional who understands the law and has experience in the law. Take some information from it, do your homework, know your statutes, and prepare your case for yourself in your situation. And I'm saying that because I've met challenges like that in cases, and in particular, a person who did quite well for themselves for a long period of time. And it frustrated the usual participants, the judges, the guardian ad litem, the attorneys, and myself. And frankly, I wasn't representing that person, I was on the other side, but I gained respect for what this person was doing. I didn't like it, of course. It made my job harder, it made it harder for my client, and I wish there was an easier path, but the person was doing an effective job. All right, so let's get into the framework. Tip number one, if you're representing yourself, is do not lie or mislead the court. Truthfulness is essential. Lying really can severely damage your credibility, and lawyers often ask questions they already know the answers to. Multiple hearings will often occur in family law, and dishonesty can come back to haunt you later. Judges remember that, and they rely on credible parties to make decisions. And I've seen pro se people lying about their income, whether they're employed, where they live and who they live with, whether or not they're using illegal drugs, if they're dependent on alcohol or drugs. They've lied about domestic violence. That all can really be legally and personally devastating to their case. Tip number two, if you're representing yourself and you do have substance abuse issues, you do need to get that under control. Alcohol or drug abuse negatively impacts decision-making and credibility, and judges take that very seriously, even if the case isn't about children. I can recall a time where a pro se party was intoxicated in court, and I asked the person, had they been drinking? The person denied it. The court ordered a breathalyzer test, and it confirmed not only was this person drinking, they were intoxicated, and that severely damaged the case. So be sober, honest, and aware that substance abuse, even historically, matters. And it's better to be honest about that than dishonest. I've seen cases really fall apart for people. Tip three is to conduct pre-trial discovery. And you can collect information before trial. It's called discovery. You can get financial records, education and employment information, witness lists. You can find out about the other side's claims. And you can use different tools. Interrogatories, requests for productions of documents, requests for admission. This pre-trial strategy helps avoid surprises and ensures a thorough preparation. So the pro se people that do this do well. Don't ask the judges for advice. It's inappropriate, it's not productive. So a well-prepared person without an attorney can disrupt an attorney's strategy with these effective pre-trial questions and really slow down the attorney and their client. Tip number four, be prepared at the hearing. Do not come unprepared. So preparation means you do, if you're being represented by yourself, you need to know the law, the statutes, the definitions, the requirements. You need to know the rules of the game. So bring your exhibits, call witnesses, plan what you want to prove. What makes it on the page makes it on the stage. Poorly prepared pro se parties tell incoherent stories, they ramble on, they fail to present evidence, they don't have witnesses to support their claim, and sometimes they even ask the court what to do, and that doesn't work well. So know your statutes, bring documentation and solutions to the court, and have a clear goal in mind and work backwards and to achieve it. Thinking like a lawyer makes a huge difference. The final tip for you guys is to always show up to court on time. Seems simple, but missing court can lead to a default judgment, which means the other side gets everything they want. It could mean loss of custody, unfavorable support orders, and more. And generally being late is just damaging. It looks disorganized, irresponsible. It might further the claims of the other party on those points. And judges assess character. They look at punctuality, they look at responsibility, and these are all essential traits. Those 5 basic things is something that everyone who's unrepresented should have down pat. Now, the last thing I would tell you is a bonus tip is do not go into court and then accuse the court of bias. Don't complain that the court favors women if you're a man. Don't complain that the court only listens to the lawyers if you're pro se. Don't go in and say the system is against you. All of that is unhelpful, and it makes you look bitter, it makes you look unprepared. If there is bias, keep that to yourself. Focus instead on just presenting your well-prepared case. Don't be distracted by these ideas. Judges respond to facts, clarity, professionalism, and really not complaints. So when it comes to family and your children, nothing is more important than that. And I highly recommend that you hire an attorney. That will get you the best results. But if that is not possible, remember the 5 tips that we've discussed today. Do not lie or mislead. Do not abuse alcohol or drugs, and get help. And don't be deceptive about your drug and alcohol use. Number 3 is, before you come to court, be prepared, discover facts, use discovery. And when you come to court, be prepared. Tell your story and tell it well. Number 5 is don't be late or miss court. And of course, that bonus tip, don't worry about judicial bias. That just lives in your head. Let it go away and just focus on your case. All right, guys, thank you for joining me today. I hope you find these tips helpful. Don't forget, visit us at hkklawoffices.com and leave some comments below. Thanks, guys.